Me, because my learned senior brother has concurred with me. I'll just read out the directions. The second part of Section 2H of the Act of 2012, which reads as and include such classes as the state government may, by notification in the official gazette specified from time to time, is struck down. Section 16 of the Act is struck down. 10 and 7% of the subclassified classes is struck down. Consequently, the subclassified classes listed in two categories, namely OBC A and OBC B, are struck down from Schedule 1 of the executive order number so and so dated 11th May 2012 issued by the government of West Bengal. Backward classes welfare department subclassifying 143 classes are struck down. The executive orders classifying 66 classes. All the arguments, you recorded all your arguments in detail. You analyzed each argument, each point, and in essence, we have allowed the writ petitions, the PIL. Now, we have given conclusions. In addition to the conclusions, we have given certain directions. I say we because my learned senior brother has concurred with me. I'll just read out the directions. The direction A. The opinion and advice of the Commission is ordinarily binding on the state legislature under Section 911 of the Act of 1993. Irrespective whether a request to look into the over-inclusion or under-inclusion is made by citizens or body or the state. The expressions government of West Bengal and government in Section 2F of the Act of 2012 is read down to mean the state of West Bengal in discharge of its legislative functions, having due regard to the reports of the Commission under the 1993 Act. C. The second part of Section 2H of the Act of 2012, which reads as and include such classes as the state government may, by notification in the official gazette specified from time to time, is struck down. Section 16 of the Act is struck down of Act of 2012 is struck down since it empowers the state executive to amend any schedule of the Act of 2012, including Schedule 1. Consequently, the 37 classes included in exercise of Section 16 by the state executive are struck out of Schedule 1 of the Act of 2012. Section 5A of the Act of 2012, which distributes the percentage of reservation in 10 and 7% of the subclassified classes, is struck down. Consequently, the subclassified classes listed in two categories, namely OBC A and OBC B, are struck down from Schedule 1 of the Act of 2012. The proviso to Section 5A of the Act of 2012 is read down contextually to read the expression state government to mean the state of West Bengal in exercise of its legislative functions, having due regard to the reports of the Commission constituted under the Act of 1993. The executive order number so and so dated 11th May 2012 issued by the government of West Bengal, backward classes welfare department subclassifying 143 classes are struck down. The executive orders classifying 66 classes before or prior to 2010 are not interfered with, since the same have not been challenged. The executive orders classifying 42 classes made by the state under the various memos from 5th March 2010 till 11th May 2012. Inter alia classifying 35 classes for the purpose of reservation under 16.4 are quashed with prospective effect in view of the illegality of such reports recommending such classification. The backward classes welfare department of the state in exercise of powers under section 11 of the 1993 Act shall in consultation with the commission place a report before the legislature with recommendations for inclusion of new classes or for exclusion of remaining classes of the of remaining exclusion of the remaining classes in the state list of OBCs. The services of citizens from 77 classes, from these 77 classes, the struck down classes, the services of citizens from the 77 classes and 37 classes added in exercise of section 16 struck down above, who are already in the service of the state or have already availed the benefit of reservation or have succeeded in any selection process in the state shall not be affected. This is only prospective. So this is these are the directions which will. Definitely. Stay is considered. Stay is considered reject.
I have
Can it be uploaded?
It will be uploaded today. Right today. The server.
Great, my lord.
Judgment, go through.
we have I have conquered. I just wanted to share this. Upon an examination of the ramifications of the present amendment, there is no doubt that the same was substantive in nature. Given the absurdity that arises upon a literal interpretation of the amended section 9, inasmuch as advice of the commission rendered in terms of subsection 1b is ordinarily binding, whereas advice rendered in terms of subsections 2 and 3 is not, I find myself in agreement with my learned brother's reasoning of adopting contextual interpretation. There is a complete lack of legislative policy within the scheme of 2012, which guides the power of the state government under Section 2H, read with Section 16 of the Act. The legislature has to lay down the legislative policy and principle to afford guidance for carrying out the said policy before it delegates its authority, its subsidiary powers in that behalf. The legislature must retain in its own hands the essential legislative functions, and what can be delegated is the task of subordinate legislation necessary for implementing the purposes and objects of the Act. The vesting of the power by an enabling provision may be constitutionally valid, and yet exercise of the power by the state in a given case may be arbitrary, particularly if the state fails to identify and measure backwardness and inadequacy. The concept of equality of opportunity in public employment concerns an individual, whether that individual belongs to the general category of backward class. The conflicting claim of individual right under Article 16(1) and the preferential treatment given to the backward classes has to be balanced. Both the claims have a particular object to be achieved. The question is of optimization of such conflicting interests and claims. The concepts of equity, justice, and merit in public employment depends upon quantifiable data in each case. If the state wishes to exercise discretion under Section 16(4), Article 16(4), it is required to collect quantifiable data showing backwardness of the class and inadequacy of representation of that class in public employment. If histories and realities of life provide any guide, it would be axiomatic to say that human ingenuity has no limits in finding out the ways of avoiding and circumventing the provisions of law, much more in cases where confidence of the people at large rests upon the government. The society at large has a stake in proper application of the yardsticks pertaining to reservation. The allegations in the instant case are neither skirmishes nor bald, but speak of overt acts indicating non-compliance of the statutory provisions and the law as laid down by the Honorable Supreme Court. Strict adherence to the rule of law is to be ensured, and the same cannot be allowed to be flouted in the hands of the executives, who dressed in little brief authority and in exercise of its discretion, cripples the constitutional guarantee of fairness and reasonableness. With these observations in elicitation of the conclusion arrived at by my learned brother, I agree with the elections.
Faithful Maharaj. Order second.